Our next speaker is Anietie Ewang. She's the Nigeria researcher at the Africa division at Human Rights Watch. Prior to joining Human Rights Watch, she worked as a senior staff attorney at the Social Economic Rights Action Center in Nigeria. She's also worked at the Initiative for Social Economic Rights in Uganda and the Nigerian Federal Ministry of Justice. She volunteers with local women's groups to promote economic empowerment for indigenous women in Nigeria. Anietie, over to you. You're very welcome.
Thank you very much. It's a pleasure to be here today to speak on the emergence of counterterrorism measures as counterterrorism financing measures as a threat to human rights in Nigeria. I think Victoria has already given me a really good foundation to work off of. As she mentioned in her presentation, Nigeria's anti-money laundering and counterterrorism framework is, they're basically intertwined. So a lot of the same laws and regulations apply. That said, I want to establish, as she did, that Nigeria has a robust legal framework to counter terrorism financing and bring perpetrators of this and other related terrorism offenses to account. As many of you know, Nigeria has a violent history with terrorism, especially in the northeastern part of the country where Boko Haram is waging a war against the Nigerian authorities to institute or establish a caliphate. And this has had really grievous consequences on citizens living in that region. And it's also had enormous consequences for citizens across the country. So now Nigeria's robust legal framework to counter terrorism financing essentially is targeted at dealing with, consists of laws and regulations which domesticate the global AML-CTF standards and make them applicable within the country. They include Nigeria's terrorism prevention law, Nigeria's Bank and Other Financial Institutions Act, which empowers the authorities to seize and freeze assets of those who are reasonably suspected to be involved in terrorism or engaged in terrorism financing. Nigeria also has regulations such as the freezing of international terrorist funds and other related measures, as well as the anti-money laundering and combating of financing of terrorism in banks and other financial institutions in Nigeria. I mean, these regulations prescribe the procedure for freezing of funds, of financial assets, as well as other economic resources of any suspected terrorist organizations. And they require banks and other financial institutions to cooperate with competent or supervisory authorities to conduct due diligence, monitor and file suspicious transactions, amongst many other things. And essentially, the authorities have also done well to be responsible for the supervision of these financial institutions and designated non-financial institutions that play a role in ensuring that they're countering terrorism financing or curbing terrorist financing across the country, including the Central Bank of Nigeria, which has domiciled within it the Nigerian Financial Intelligence Unit, which is a central coordinating body for the country's anti-money laundering and counterterrorism financing framework. There are other supervisory institutions, including the Corporate Affairs Commission, which serve in various functions to ensure that there is compliance on most part by companies and financial institutions alike. Now, I mean, at Human Rights Watch, I spent a lot of time documenting human rights abuses within the context of terrorism in the Northeast. And I think one thing that became clear in our years of work in this particular sector is the fact that while there are legitimate claims that the authorities have used to bring charges or open terrorism investigations against several people or groups, the authorities, on the other hand, have regularly abused counterterrorism legislation and use them as a pretext to violate rights. So you see them regularly opening investigations or bringing charges against people who are critical of government or who hold opinions or ideas that challenge government's actions or inactions. There's several instances in the past where journalists or activists have been arrested and detained and charged with offenses under the Terrorism Prevention Act for pretty much publishing information that is critical of government or carrying out protests to call the authorities to ensure that they're respecting or promoting human rights in one way or the other. The authorities have also used counterterrorism legislation to prescribe religious groups and separatist groups such as the Islamic Movement of Nigeria, which is a minority Muslim sect in the north, and the Independent People of Biafra, which is a separatist group that is agitating for an independent part of the country. They've also used counterterrorism legislation to target humanitarian agencies working in the Northeast, essentially because in many cases they have stood firm on the position that they are supposed to be independent in line with international humanitarian law and not tilt in favor of the government in carrying out their activities in the sphere of the conflict, within the sphere of the conflict. But I think we didn't really see counterterrorism financing laws being used as a basis for human rights until 2020, or rather it became more obvious in 2020 during what is now known as the EndSARS protest against police brutality, which took place across the country. And it was essentially spearheaded by young people who were really tired of police brutality. It was a phenomenal time in Nigeria's history. We had protests in over 20 cities across the country. It was a time that the authorities were really brought to a standstill and made to understand the gravity of the issues that citizens were facing. But I think in an effort of the authorities to suppress the protests, the Central Bank of Nigeria instructed private banks to freeze the several bank accounts belonging to individuals and groups who had been receiving or disbursing funds to support the protests. So essentially, bank accounts with transaction records that included references to EndSARS were frozen without any prior notice or legal proceedings. And this contributed to stifle the protests as, the services that were being provided to protesters, including water, food, and emergency healthcare at most locations were interrupted or completely cut off. Following this, the central bank went on to obtain a court order the following month, which directed local banks to freeze the bank accounts of those who were targeted for a period of 3 months on the vague basis that these accounts were under investigation for alleged offenses. There was nothing more than that. And then there was a supporting document which said they were involved in terrorism financing via their bank accounts. This application was brought pursuant to Nigeria's Bank and Financial Institutions Law, which empowers the court to grant orders to freeze banks on the suspicion of criminal activity. And this punitive measures essentially cut all of those people from accessing financial services and also had a huge impact on their ability to provide for themselves and their families and to be able to sustain their businesses. So here we saw a direct violation of human rights on these individuals. And I think the question is, how can this happen, right? And the one answer that is very obvious is that this is in line with the broader issues of impunity and lack of accountability of the Nigerian authorities that we see. Nigeria has a very poor history of human rights, and we've seen time and time and again that they've used as many laws as possible where it has been necessary, in their opinion, to sort of stifle rights. And so we saw that they've been able to use the counterterrorism financing laws as well in this situation. Already Nigeria's laws, including the Terrorism Prevention Act, which gives the authorities power to seize and freeze assets of people who are suspected to be involved in terrorism, and the Banks and Financial Institutions Law, which empowers the court to grant orders to freeze bank accounts on the suspicion of criminal activities, are very broad. Because these provisions in the laws that pertain to these particular issues do not clearly stipulate a threshold. There is no clear definition of terrorism in Nigeria's counterterrorism law, its main counterterrorism law, which is the Terrorism Prevention Act, Section 1 of which defines an act of terrorism as that done deliberately with malice aforethought and which may seriously harm or damage a country or international organization or unduly compel the government to perform or abstain from performing an act. It is really broad. And we found that it's giving the authorities a wide scope to act in a manner that poses huge threats to fundamental human rights. Also, we've seen that apart from the gross abuse of power, which the authorities have shown in this particular case, the courts are also not effective in interpreting and applying counterterrorism financing legislation in a way that defends human rights. So there are basic reasonability tests that should be passed before orders to freeze assets are granted. But we've seen that the courts have been unable or unwilling to be able to ask those hard-hitting questions to the relevant authorities, including the CBN, when they've brought applications to freeze such assets. And this is down to a couple of things that many people would argue. One, that the judiciary lacks independence, or that they haven't been exposed enough to the framework and the sort of benchmarks or thresholds that should be applied in really determining how to apply the legislation or the regulation on counterterrorism financing. And there's also the question of whether or not they can actually do it without the influence of the authorities. And I think I'll say that in discussing a way forward, when we are talking about transplanting AML or CTF policies or laws, and doing that by taking into consideration risk, there has to be a specific risk assessment for human rights within the context of that country. So when we are pushing for the transplantation of counterterrorism financing laws, there has to be a risk assessment that really takes a look at the proposed or now existing laws that we have, and a parallel look at whether or not there are existing laws or frameworks that are enough to address the identified risk with regards to human rights. And if they aren't, there's a duty at that point to push for these safeguards in laws or through other channels. And I think one of the other channels in which there can be adequate scrutiny is through the engagement with stakeholders, core stakeholders, including civil society groups and the judiciary, which both play a key role in determining how the standards or the laws and policies with regards to counterterrorism financing are adopted and implemented in a way that, that they respect rights. So call them whistleblowers in a sense, or just standard gatekeepers, standard keepers. There has to be a sort of critical engagement that takes place within the context of the risk that human rights, that these laws pose to human rights, that is specific to the country. I'll stop here, and I'm happy to answer any questions that anyone has for me.
Thank you very much. It's been another very enlightening presentation. We have a